Margaux Hall. I'm a partner in the Healthcare Regulatory Group of Ropes & Gray based in Washington, D.C., currently out of my home office. And much of my practice focuses on drug pricing. I advise pharmaceutical manufacturers and other companies on a wide range of business, legal, and policy questions that relate to drug pricing. And so I'm happy to answer questions today about managing drug costs and the role that corporate counsel and employers generally, as sponsors of insurance, can play in understanding and managing their drug spend. So when individuals mention drug prices, either in everyday discussion or in policy discussions, I always pay close attention to what specific pricing measures they're referencing, because there are multiple potential pricing measures at play, only certain of which would be visible to a patient. So first, there's the list price, which is the price that the drug manufacturer sets for a particular therapy. Then there's also the price that a health plan pays for the drug, and that price frequently reflects discounts off the list price. And then there's also the price that an insured patient actually pays under his or her health plan for a drug, whether that be a copayment, like a flat dollar amount of some sort, or else a coinsurance amount when they have a particular drug dispensed or administered to them. And that price, the price that a patient pays for a drug, often has, an attenuated at most connection to the list price of the drug, or for that matter, the price that the health plan pays for the drug. At a 10,000-foot level, many health plans look at determining patients' overall health costs for health benefits by reference to determining an overall actuarial value of a health plan. In other words, the plan calculates the percentage of total average costs that the plan, as compared to the patient, will bear for covered benefits. Patients can pay for their share of covered benefits in different ways, apart from what they pay each month, typically in the form of a premium. And when it comes to drugs, many plans will put in place a so-called formulary that contains drugs that have preferential coverage under the particular plan. Within that overall formulary, plans may have different tiers of drugs, and the different tiers may have their own cost-sharing arrangements attached to them. So for instance, in a particular plan, the drugs in the lowest cost tier might have a flat $5 copayment amount for patients, while drugs in a higher cost-sharing tier might be subject to a 20% coinsurance cost-sharing amount that's applied to the price of the drug. And then on top of that, increasingly plans are designing a tier for specialty drugs, which are often higher cost drugs. They could be biologics, they could be therapies for different forms of cancer. And so many plans have segregated a tier for that particular category of drugs, and they might apply a different cost-sharing approach for that specific category of drugs. So in recent years, there's been extensive discussion about the role of middlemen when it comes to drug pricing. And there are several intermediaries that play a role in how patients access their drugs. That is true irrespective of whether a patient gets a drug from a retail community pharmacy, a brick and mortar pharmacy, or has a drug, injected, infused, administered in a physician's office or a hospital. The distinction is there might be different middlemen or intermediaries at issue depending upon the particular drug, as well as the place where the drug is going to be administered. I find when many individuals talk about middlemen, they are referring to pharmacy benefit managers, known by the acronym PBMs. PBMs are companies that contract with health plan sponsors or employers to administer the pharmacy benefit. And that PBM will generally set up the formulary, often by negotiating with drug manufacturers to receive a rebate or a discount in exchange for the health plan agreeing to offer preferential access to a particular, that particular drug, and preferential as compared to competitive therapies that could be used to treat, the same condition. Many of the recent controversies and policy debates around drug pricing relate to this question of which parties receive the benefit of those negotiated rebates and discounts. And from the perspective of an employer, whether the employer, or importantly, the patients, the employees and their families, actually see the benefit of those discounts when it comes to what they pay for drugs. So this is a topic that increasingly has come up given the significant role that employers play in providing employees and their families with coverage for drugs and more broadly health benefits. I recall, Howard Schultz, the former CEO of Starbucks, reflected several years ago that Starbucks spends more on healthcare than it actually does on coffee. And I find that very, reflective of the fact that for many employers, their core business model does not relate to healthcare. And yet, by virtue of their role as sponsors of health insurance, they spend a tremendous amount on health insurance. And it's pivotal to their broader strategy around this, employee recruitment and retention, as well as, it very well could align with their broader corporate commitments. As a legal matter, there aren't many requirements regarding what drugs employers must cover or under what particular terms when it comes to employer-sponsored insurance. But as a practical matter, there are steps that employers can certainly take in this space. For instance, encouraging the entities that administer their drug benefits to pursue design options that create the right incentives for patients to use cost-effective therapies. And those formularies, when they're designed, can contain cost-sharing incentives that aim to enhance patient access to high-value therapies under the perspective that those therapies will help keep patients healthy, and over the long run will have a positive impact in terms of overall healthcare expenditures and keeping those down. And in recent years, there's been much more attention paid to those negotiated rebates and discounts on drugs. And I have found that increasingly employers and other sponsors of health insurance have been scrutinizing their contracts and negotiating rights that require intermediaries to, first of all, disclose the amount of those rebates and discounts, but then second, also pass through a particular percentage of those discounts to help hopefully put downward pressure on both employers and patients' costs for therapies. The contractual terms around that all can be complex and nuanced, and so it requires close attention to detail to really understand from an employer's perspective that you're negotiating the best overall deal. And also, this is a space where there's just such rapid evolution, both in terms of the business arrangements and the different intermediaries at play and the types of discounting and financial arrangements that they structure, but also importantly, the legal framework that governs all of this. And so that, in my view, may merit revisiting those contractual terms on a more regular basis. So for instance, perhaps reviewing the contractual terms every 2 years rather than over an extended period of time to ensure from an employer's perspective that you're really getting the benefit of the best bargain possible. So that's a key market trend. And, again, here too, employers and other sponsors of health insurance are seeking to be really creative when it comes to balancing the need for cost control as well as the desire for robust patient access when it comes to these specialty drugs. Many of these drugs, as I mentioned before, they can be higher cost. They're often used to treat these serious complex conditions. And there's a considerable pipeline of specialty drugs that are in the queue to receive approval from the U.S. Food and Drug Administration in the coming years. So this certainly is an area where there's going to be, further pressure, further opportunities for employers to be creative. Certainly, there are innovative approaches that could be pursued here. I mean, as an initial matter, would say when you're talking about a higher cost drug, that merits additional vigilance when it comes to thinking about any rebates or discounts that might be offered and ensuring that those rebates and discounts are really accruing to the benefit of the employer and the patient. But also, increasingly, there are opportunities to pursue innovative contracting arrangements for some of these specialty drugs. So, for instance, value-based contracting, wherein a payer only pays for a drug if the drug meets certain performance metrics, and there's a so-called value-based case, right, for actually paying for that drug. And so those are some of the changes that are underway, and certainly I see many opportunities to try to include those types of approaches as part of the broader approach to benefit design and contracting strategy. So drug pricing is a topic that's been front and center in the news cycle over the past 4 years. In reality, though, up until a few weeks ago, most of the Trump administration's efforts to restrict drug prices or require certain reforms when it comes to drug price transparency had been unsuccessful due to legal or political obstacles. So, for instance, in July 2019, we saw a federal district court strike down agency efforts to mandate that drug makers disclose in TV ads the list prices of drugs if those drugs are covered by federal healthcare programs. And the district court found that the agency had exceeded its legal authority. But starting in late October of this year, there's been a flurry of rulemaking, and in particular, final rules that have been issued that are scheduled to go into effect. And many of those stand to fundamentally change drug pricing arrangements in the market, as well as potentially change the overall transparency of drug prices. So, for instance, a final rule was released that requires certain health plans to disclose, as of the year 2022, the negotiated price that an insurer has agreed to pay an in-network provider for a particular drug, as well as the historical average net price the plan has paid for that particular drug, taking into account all discounts. That's a significant change when it comes to drug price transparency, given that traditionally privately negotiated commercial market arrangements between a health plan and a provider would have been just that. They would have been private, right? And they were subject to fairly strict confidentiality provisions and protections. Making that information available to the public will be a significant change when it comes to drug pricing. And then separately, just a few weeks ago, in November, an interim final rule was released that launches a nationwide demonstration program that will link the prices for certain physician-administered drugs in the Medicare program to the prices that are paid for those drugs in various foreign countries. This so-called Most Favored Nation demonstration program is scheduled to go into effect January 1st, 2021, and it will have a 7-year term. So these have been really significant developments in the span of just a few weeks, and I expect that various of these final rules will be subject to legal challenge. The upshot is that after a relatively quiet 4 years when it comes to drug pricing, the final days of the Trump administration have been extraordinarily busy when it comes to reforms in this space. I expect that various late-stage Trump administration rules will be challenged in court, and those might be tied up in litigation for quite some time. I also expect that the Biden administration's focus, first and foremost, during the initial days in office, will be on the COVID-19 pandemic and working to facilitate the rollout of vaccines and therapeutics for COVID-19. Beyond that, in general, the Biden administration is likely to take reactive steps to many Trump administration regulatory actions, including potentially by postponing rules that have been published but are not yet effective, and using the notice and comment rulemaking process under the Administrative Procedure Act to issue its own regulations that rescind Trump-era regulations. So I expect that will be a general approach of the incoming administration, but there's a big assumption, right? And the underlying question is whether Biden would want to unwind the Trump-era regulations. And when it comes to drug pricing reforms, there are big question marks in my mind with respect to how Biden will come out on some of these drug pricing topics. We know that incoming President Biden has an ideological commitment to addressing drug prices. He's proposed various concepts, including the concept of having the government directly negotiate for the price of drugs in connection with the Medicare program, and also the general approach of linking prices of drugs in the US to pricing figures in other countries has been embraced by Democrats in the past. We don't yet know, sitting here today, the ultimate balance of power in the Senate. So until those Georgia runoff races are completed, we won't know whether the Biden administration is going to have to contend with a Republican-controlled Senate. I mean, if that is the case, then legislation around drug pricing would require a consensus viewpoint. That's not impossible, but in recent years, that's certainly been lacking in DC. And if that continued to be the case, then incoming President Biden would be left with executive orders and regulatory tools at his disposal, and there would be limits to how much he would be able to achieve in terms of reforms around drug pricing if he's looking at regulatory changes. So on the whole, I expect that drug pricing will be a priority of the Biden administration, perhaps receiving more proactive attention after the COVID-19 pandemic has dissipated. Well, many of the recent and emerging drug pricing proposals aim to reconfigure the pharmaceutical supply chain and intend to create pressure on drug manufacturers to lower their list prices. There's a big question with respect to many of the proposals or plan changes, in terms of whether they will really result in lower list prices. At the same time, we're seeing the pharmaceutical supply chain and that landscape of intermediaries and also the business contracting relationships continue to evolve. So as a practical matter, that likely means that employers, as sponsors of insurance, are going to need to scrutinize new contract provisions when it comes to arranging for employer-sponsored health insurance and drug benefits specifically. And we'll need to give thought to how the negotiated terms are going to ultimately impact employers and patients' healthcare costs. Given the complexities in how drugs are paid for, it's not inevitably true that lower list prices would result in lower prices for employers or patients. And so this is, an area that I think requires vigilance, especially when it comes to looking at those contractual terms. And in recent years, we've seen employers increasingly scrutinizing those contractual rights to make sure that they benefit from rebates and discounts that are negotiated in connection with a particular drug. That will remain as important as ever from a cost management standpoint. So three thoughts. First, stay up to date on the changes that are afoot. No doubt the media is going to continue to cover the topic of drug pricing as well as cover the proposed legal reforms in this space. It's an important topic to follow as corporate counsel, given that many employers do wear that secondary hat as sponsors of insurance for employees and their families. Second, scrutinize your contracts. I suggest asking for information about proactive plan benefit design that can promote cost-effective care when it comes to drugs and, healthcare services, items and services broadly. And I recommend carefully reviewing that contract, given that the terms can be nuanced. And on the whole, it's important to pay close attention to ensure that employers are negotiating the best overall arrangement for themselves and for their employees. Also, given, again, this rapid evolution in the pharmaceutical supply chain, I think there could be good reason to look at those contracts more frequently. Third, various innovative approaches are available and increasingly employers have been using them. So value-based payment options may be worth exploring as part of the overall corporate strategy, especially as an increasing number of specialty drugs come to market. And the approaches may vary as well depending upon the size of the employer and the lived experience in terms of what health spend under the plan is looking like on a retrospective basis. But there certainly are proactive management tools, and all of this really merits close engagement and watching. I tend to find that this is a really fascinating area of law and of sort of business practice to follow. I recognize I'm biased as somebody who works in this area every day, but I do think it's important to broader corporate business strategy, and I anticipate there will be many changes to keep close watch of.